Okay, welcome everyone. This is the City of Annapolis Board of Appeals special virtual meeting for January 20th, 2021. Meeting's being broadcast on the City of Annapolis YouTube channel. My name is Bob Gallagher. I chair the board. In accordance with the city's policy during the pandemic emergency, this virtual meeting allows the public to observe the meeting through this video link and to submit written comments through the City of Annapolis website. Links to the YouTube channel and the channel for written comments may be found on the agenda for tonight's meeting. So first we'll ask our recorder, Tammy Hook, to please call the roll.
Mr. Gallagher,
Yes.
Mr. Barnett,
Present.
Mr. Dews,
Present.
Mr. Walsh,
Present.
Mr. Zazali, Dr. Chen.
All right, so we have a quorum and we'll begin this evening's program. Before we take up the agenda, a couple of more points on our virtual format. If you're not a party and just watching from home, people that you see on the screen are members of the Board of Appeals. When a case is called, the representatives of the parties to the case will also appear on the screen. Also participating in the meeting are counsel of the Board of Appeals, Cheryl Woods, our recording secretary, Tammy Hook, and one or more city employees managing the broadcast and recording ends of things. Also participating, there may be other representatives from the city, including Dr. Sally Nash, Director of Planning and Zoning, Joelle Braithwaite, Assistant City Attorney and Counsel to the Department of Planning and Zoning, and one or more other members of the planning staff. We ask everyone but the members of the board to mute their audio. If anyone else wishes to speak during the meeting, please raise your hand and I'll call on you to do so. As I mentioned earlier, written public comments were accepted through the city website. Comments on matters before the board tonight that were submitted up until noon today are made part of the record and have been forwarded to the members of the board and the parties in advance. In order to allow additional comments in response to matters that arise at the hearing tonight, the record will remain open in those cases in which evidence or argument are received until our next meeting on February 2nd, 2021. Any additional comments received until noon on that day also will become part of the record and forwarded to the members of the board and the parties. Now we will look for approval of the agenda. With the permission of my colleagues, I suggest one change to the agenda. If we move the variance ahead of the appeal, I don't expect it will take too long, and we'll be able to excuse the applicant as well as board member Walsh, who will not be participating in the appeal matter. So with that suggested amendment, do I have a motion to approve the agenda?
I move that the agenda be approved.
Do I have a second?
Second.
All in favor?
Aye.
Aye.
Someone has something to say? Okay. All right. The first matter then will be variance 2020-007, variance application by Douglas C.K., property owner, for a reduction to the required side yard setback of 6 feet to 2.33 feet and 3.67 feet, or 61% reduction, for construction of a covered front porch to align with the existing side of the dwelling structure on property located at 121 Archwood. We heard the evidence and argument in this case on January 5th. Do we have any additional public comments?
No, this is Cynthia from the Planning and Zoning Department. We have not received any public comments.
Excellent. All right then, so the evidentiary record is closed and we will conduct our deliberations. All of the board members who are on the Zoom call now participated in that. So let's see what we'd like to do. So let's pick on Rob. See if he has any suggestions. Would you like to go first, Mr. Dews?
Sure, I can go first. After reviewing it, I didn't see, I didn't come up with any new questions after the discussion that we had on the January 5th. So I really didn't have anything to, all the information I think that was provided was pretty clear. So I really didn't have anything else that I needed additional information on. I know real questions. I have my thoughts on it. Like to hear everybody else, but I've kind of got the way I feel about it, you know, and after reviewing the case a little while ago for my second time.
Okay, Michael?
Thank you, Mr. Chairman. Yeah, I reviewed, I thought the testimony provided by Ms. Taylor and by the applicant were consistent with a granting of a variance. It met what I think to be the criteria. It certainly is not for personal gain. It is unique to that particular property. It's consistent with what's in the neighborhood, and you know, I would be inclined to approve the variance.
Mr. Burnett?
You know, I'm all about brevity, Mr. Chair, so I'm not going to repeat what my colleague said. I have nothing to add. I think it meets all the criteria, and I'm inclined to move forward with a vote.
Well, I agree. I think they touched all the bases. They met the hardship and the uniqueness tests and the other tests that you've all referred to. And so based on the staff recommendation and all the attachments and the evidence we heard on January 5th, I'd be delighted to entertain a motion to approve the variance. Do I have a motion?
Mr. Chairman, I move that variance 2020-007 be approved. Cynthia, quick question. Did the staff have any recommendations attached to that I'm trying to recall?
You mean conditions?
Conditions.
There was a list of conditions.
Standard
Conditions.
Yeah, pretty standard.
Design. Yeah.
Yep, they were pretty standard.
So I would move that variance 2020-007 be approved, including the conditions outlined in the staff report.
Do I have a second?
Second.
All in favor?
Aye.
Aye. Okay, that's terrific.
Bob,
Yeah.
Mr. Lomax is not able to get into the meeting. I just called him and he said he can't get in.
Well, why don't we have our technical staff help him?
Yeah, he is in the meeting. I just had a hand raised and then it lowered.
Oh,
I might
okay.
be referring to microphone, but
Okay.
I believe that's the next agenda item.
All right,
Right.
so congratulations, Mr. Kay and Ms. Taylor, and we'll excuse you at this point.
Thank you.
Thank you, Mr. Gallagher.
Thank you.
Thank you, everyone.
And then Bob, one more thing. I've had a text from Christian and he had outpatient surgery today and he's loopy.
Uh-oh.
I'm reading verbatim. So he's not going to be joining us.
More loopy than we are?
Well, apparently.
Okay. All right, so we have, let's see. We're still looking for the applicants and Mr. Lomax here. I mean our appellants, yeah. All right, Mr. Lomax.
Mr. Chairman, as you noted, I recused myself from this case, so I will go off. I will mute myself and go off of video and wish you Godspeed.
Thank you, Mr. Walsh.
Is he coming back because you skipped over the minutes?
Oh, sorry.
Oh,
Let's
I'll
do
wait.
that
Wait till
quickly.
we do the minutes.
Have my board members had a chance to look at the minutes for January 5th, 2021?
Yes.
Are any corrections or additions?
No,
No.
I have a motion to approve them.
so move.
Second.
All in favor?
Aye.
Aye.
All right, motion, the minutes are for January 5th are approved. All right, let's see, who are we missing? We have Mr. Averill. Do we have Mr. Lomax? Do we have all your clients we're expecting?
I am looking. I have Mr. Bernard, I have Mr. Guckus, I have Mr. Latazori, and I suspect if Mr. Guckus or Mr. Bernard unmutes, they can confirm that Mr. Schwarzler is with one of them.
And Mr. Averill, are we waiting for your client?
Mr. Chairman, this is.
No, Mabel Adams Krieger is here.
She is here. Okay, great.
Mr. Chairman, this is Hugh Bernard. I have Gary Schwarzler in the house with me.
Good, thank you. All right, we'll turn right to this one now. So we're turning to Appeal 2020-006, appeal application by Franklin H. Bernard, John Latazori, Fred Guckus, and Gary Schwarzler of the decision by the Planning and Zoning Director concerning the approval of the residential neighborhood conservation site design plan review application RNC 2020-002 for the demolition of the existing single-family dwelling and the construction of a new single-family dwelling on property located at 613 Chester Avenue. This case was continued from January 5th for hearing on the merits of the appeal. So I think we have the appearances. Have we any public comments been submitted since the last hearing?
We don't have any additional public comments since the last meeting.
All right, thank you, Sally. Are there any remaining disputes over what's in the record and what's not that we have to deal with?
I don't believe there are disputes as to the record, but the city does raise two preliminary issues in its objections to moving forward. One being there's one filing fee paid, and it's not the case that four appellants are arguing that each of them paid a filing fee or that each of them even perfected under the law in terms of this appeal.
Go ahead. That one's clear from your papers.
Oh, and then the second issue, of course, would be objecting to the late raised issue about HPC demolition.
Yep.
Since that was not raised in September 15th.
That's noted. We'll get to that directly.
And also the city would like to put the board on notice that Kevin Scott will be dealing with the substance of the merits of the appeal, dealing with the factual side. And I'm just intend to make argument, if allowed, prior to his discussion of the factual part of this discussion tonight.
That's fine with me. You might want to consider whether you do the argument after, because that's where they're more likely to be questions, but I'll leave it up to you.
Mr. Chairman, I have a question. I don't know whether there's an objection here or not. The parties were directed to provide pre-hearing memoranda because this is a record on appeal.
Yep.
What I don't know is I have not seen anything from Mr. Scott. The only thing I received was from Mr. Brathwaite, and so I have a concern about Mr. Scott now putting in information for which I have rebuttal to what Mr. Brathwaite has put in, and I intend to present that. But I do have concern about now Mr. Scott tag teaming and adding what I don't know he's going to add.
Well, I suggest you hold your concern until we get there. Mr. Scott will not be permitted to testify about anything that's not part of the record. And you've got the record, so anyone who wants to talk about the record ought to be able to talk about the record. All right, so The board has reviewed the parties' briefs. Thank you very much. They're helpful, as well as the record. The members of the board may ask questions anytime during the party's presentation, but my preference would be to wait until the conclusion of each party's presentation. But that's not a hard and fast rule. If you feel the need to interrupt, you're certainly welcome to do that. We ask each party to try to limit their argument to 20 minutes. The order, as I think we announced before, is going to be the city, the appellants, and the applicants. If we need rebuttal, we'll consider that. And if the appellants need a last word, they're entitled to have the last word since it's their burden of proof. So we'll get to Mr. Braithwaite's procedural issues. So maybe there's a short way to do this, and maybe there isn't. It's my understanding from my review of the record that the application for appeal was signed by 4 people, that 3 of them were involved in the administrative process, that they all live close by to the project and have an interest in it. I don't think there are any questions about proper notice to the public. So let me ask you, Mr. Braithwaite, if we had 3 more filing fees, would that satisfy your objection?
I do believe so. I do. Yes. Short answer, yes.
Okay. So we'll go ahead and we'll hear the case the way we plan to hear it. But Mr. Lomax, your clients can pay 3 more filing fees, or you can pick the one that you want to be the.
Your Honor, if I could, Mr. Gallagher, if I could address that, because I did have a response to that, and there was no provision for filing a written response. So at least for the purposes of the record, I would like to put those brief remarks on the record.
Sure, go ahead.
So I'll be very brief. 2130-020 does not make any limit on the number of appellants or require separate appeals. It does not even mention person or persons. It simply says that an appeal may be taken by filing with the P&Z director a notice of appeal. There's no limitation on whether it's 4 names on 1 piece of paper, 1 name on 4 pieces of paper. The Article 3 of the rules also, which address the procedures, do not require or do not limit the number of appellants or require separate notices. The only thing that requires a separate notice is something coming from planning and zoning who wants 4 fees to be paid. But nothing in the rules and nothing in the code requires that. I also,
Mr. Braithwaite has dropped that. All he's talking about is the fee. You don't have to talk about notice. You don't have to talk about signing the application. That's all conceded.
I'm confused. I thought there's nothing about the fact of paying 4 fees either.
That's your argument. I understand. Have you concluded your argument on 4 fees?
I have, but if we're going to have the issue about paying 4 fees versus 1 fee, then I do need to speak with my clients as to whether or not they're prepared to pay 4 fees or 1 fee, which I've not had an opportunity to do. I would ask the staff, what is the filing fee?
Can anyone tell us? Sally, do you know?
I have no knowledge. Yeah.
I can look it up real quick.
It's a little hard to ask my clients if they're willing to pay a fee until we know what it is.
We don't have to decide that tonight, as long as it's decided by the time we reconvene on February 5th. We'll go either way, but my inclination is that, and I may be wrong because I suspect it's the case that planning and zoning has not required multiple fees when we've had multiple appellants in the past.
Mr. Chair, this is Kevin Scott. I looked it up. The appeal fee is $250.
And Mr. Scott, do you know whether planning and zoning has charged multiple appeal fees when we've had multiple appellants in the past?
The fee is for an appeal application. I see it, chapter 2130 or section 2130.010. It does say an appeal to the Board of Appeals by a person, singular, if
I'm
that
just
helps
asking-
our argument.
No, it's a very narrow question, Mr.
Yeah.
Scott. Do
Yeah.
you know whether planning and zoning has charged multiple fees for multiple?
I do not know that answer.
And I could probably say no, that has not been the case in the past. The first time we raised the defense was in the Eastport loss appeal. So I don't anticipate that this was the way other people looked at the code and interpreted the code. But it is the position of the city, and we will appreciate a ruling.
So my ruling is that while I may disagree, I think it's not an unreasonable interpretation of the code, and we're going to defer to the city on that. So Mr. Lomax, you've got until February 5th to decide how many appellant clients you're going to have at the time you decide the case. All right, now let's get to the next procedural issue. And that is the HPC business. So, so the notice of appeal, well, why don't you each give me a short argument on that one? But if you would, Mr. Braithwaite, you can start, but tell me what you think is covered by the one sentence statement that was in the notice of appeal. Is it your position that everything except, so let me ask it a different way. Is it your position that this board cannot conclude that the director's decision is unsupported solely because it's inconsistent with the HPD recommendation?
So there are facts to be determined about that. I do not believe that the appellants were certain that the HPC decision undermines this this appeal, or actually they may be asserting that, but I can explain to you why that wouldn't be the case. Quite simply, two things. One of which is the city code that requires the notice of appeal, requires that appellants specify the grounds, and the word used in the city code is specifying the grounds of the appeal. That sets the outer bounds and the scope of the entire appeal. What we see here in this case is that Mr. Lomax, on entering his appearance for January 1, he introduces a new issue. In the notice of appeal, and a very detailed letter was submitted by the four appellants, and they listed 3 reasons that the decision of the city was wrong. And we are limited by that notice on that day that we received. Those were the issues raised. If they wanted to amend their notice to include an additional appeal levers or mechanisms or issues, they would have had to do that before the close of the 30 days. The 30-day filing requirement is the time limit within which you must state your issues with us. On the date that expired for them to state their issues, they had 3 appeals issues and not 4. And therefore, because the city code is not a notice pleading, but this requires specificity.
Tell me what the 3 issues are that you think are not troublesome.
Succinctly put by Mr. Lomax, they allege error in the approval of the additional height allowance. They allege error in the calculation of the front yard setback, and they note that and they allege error in the fact that the front elevation is not consistent with the scale and character of the other houses in the immediately surrounding area.
Okay. Now I think they also asserted that approving the demolition wasn't proper.
Yes, but that was late raised. That was nowhere in the September 18th papers. It's not until January 1 that we get notice of this newly raised issue after Mr. Lomax is retained.
Well, Mr. Lomax, can you read me what was the statement in the original notice of appeal?
So I'll start with the September 18th, which was the letter notice of appeal. And the very first sentence right out of the box says, and I have to get that letter. Unfortunately, they're not indexed alphabetically, but bear with me. It starts out, and this is in Exhibit P3. We, the undersigned, are submitting this appeal to the approval of RNC 2020-002, the demolition/site design plan review for 613 Chester Avenue, planning and zoning letter dated 19 August 2020. And the 19 August 2020 letter specifically on page 3 addressed the issue of demolition. And but since this is an appeal on the record, frankly, demolition is an integral part of that record, and that issue is properly before the board. I might also note that the demolition is tied part and parcel to the request to have a replacement structure. And so to that extent, they are integral to each other. But I also have a more fundamental issue with it with the current status of the code and the rules, because here's the conundrum that Mr. Braithwaite's position presents. The code says appeals are now on the record, which is fine. We're not very used to that. But Rule 8 still says it's a quasi-judicial de novo review. Yeah. And while the code would normally trump the rules until the rules catch up, we have the problem that was pointed out earlier by the chair, that public comments are left open, not only have been allowed, but have been left open. And those public comments are not subject to any limitation about issues noted on appeal. Those comments can come in on anything or everything, and yet the appellants are being asked to be very narrowly confined to what their appeal is. I suggest to the board that until the board has lined up its rules and its procedures such that everybody is playing by the same rules, this is an appeal on the record of the entire record. And I also point out that an appeal, for example, which can be taken from this board to the circuit court, but the appeal on a judicial review only requires a request for judicial review, a statement of the order, etc. And there is no statement of issues necessary until you get into the memorandum stage. And we're in this conundrum that I can have individuals raising issues in the public comment section that I, as the attorney for the appellants, and the appellants cannot raise. And that is fundamentally not fair to the appellants under this oddball situation that we have of new code, old rules.
Your concerns are, I think, without much basis. There is a conflict. The de novo language is in conflict, and that will come out as soon as we get revised rules out. You're right that statute trumps rules. It's on the record. The comments that we receive from the public, if they're received prior to a decision by the director and considered by the director, become part of the record. And if there are any of those that the director relied on, I'm sure we'll hear about them. The comments that have been filed by the public are not part of the record, and the decision won't be based in any part on those comments. Does that help you?
Well, it does, except that it's kind of like an instruction to a jury to disregard the information, because the board just admitted all of those comments as made them a part of the record. And if this were to go beyond this board,
we did not make them part of the record. They're part of the file in the case, but they're not part of the record on appeal. I think you can appreciate the difference.
I appreciate the difference. but I beg to disagree respectfully that this issue is precluded, and I have preserved
But
that.
what issue is precluded? I haven't precluded anything. What are you talking about?
All right, then I guess I really need clarification is the issue of the approval of the demolition in this appeal or out of this appeal?
As far as I'm concerned, it's in. You haven't heard me say anything different.
Okay, then I withdraw. I'm ready to move on.
Okay.
Well, briefly, I think Mr. Lomax is a talented attorney, and what we heard a mismatch of the different conversations we're having, but it wasn't strictly along the lines of a real rebuttal to anything the city is saying. Mr. Lomax knows that in appellate practice, you petition the court and you say, here are the issues I wish you to hear, and then there's a briefing schedule which is separate and distinct, where you are able to fully flush out the issues that you raise more briefly in the notice of appeal. Here, our city code says specifying. Specifying is literally the term used. Specifying requires specificity. Sorry to use the words like that, but that's what it requires. It requires that they tell us within 30 days what is the reason our decision is wrong. Nothing in our code gives someone to file a paper with nothing on it and then come back later and allege the errors because it'll be an incomplete application. Our code requires the notice to the city as to what is the error. We received their notice. It contained 3 allegations of error, not 4. And that's the city's position.
Okay. To the extent and I'm still not clear, to the extent you're arguing that the board cannot upset the director's decision solely because it's inconsistent with the recommendation of the Historic Preservation Division, I agree with you. We're not going to raise that, but the Historic Preservation recommendation is clearly part of the record, something that the Planning and Zoning Director was aware of. If she didn't ask for it, she might have even asked for it. And so it's fair for the board to consider that as part of the record and whether it supports the decision or doesn't support the decision. So,
and again, and the city accepts your decision, and we will could move on now to.
Excuse me, may I interrupt 1 second? There's some misguided information that's being bandied about, you all. HPC has no jurisdiction at all. It is not the HPC that made any decision. If you look in the record, it is Roberta Lehner, who is the director of Historic Preservation.
May I know who's talking, please?
It is not the Historic.
May I know who's speaking, please?
Terry Averill, I'm sorry.
All right, Mr. Averill.
The Historic Preservation Commission, it has.
That's not an issue in this case, whether they have jurisdiction.
But everybody is referring to a letter as if it's from the HPC. It is not from the HPC.
It is from the HPC.
Lehner.
No, it's from the Historic Preservation Division.
No, it is not.
Division.
It is not.
Who's it from?
Not. The HPC is not the one that made that decision. That is a
I'm
commission.
not saying HPC. The letter I saw said Historic Preservation Division.
That is Roberta Lehner, yes.
So what are you arguing about?
Everybody is referring to HPC. That is the Historic Preservation Commission.
I'm not referring to it.
I've heard it 20 times in the last.
You haven't heard it from me, and when it's your turn, you can make your points. You're third in line.
Thank you.
All right. Okay. So Mr. Braithwaite is going to go first, and he's going to focus on, or Mr. Scott are going to focus on how the record supports the determination, specifically the determination to permit the demolition, to permit the increase in height, to permit the moving the front yard setback, and compatibility. All right.
And now I will yield my time to Mr. Scott.
Thank you. Mr. Scott, it's always good to hear from you.
Thank you, Mr. Chair. Okay, my name is Kevin Scott. I'm a senior planner with the Department of Planning and Zoning. I've worked for planning and zoning for over 20 years. During this time, I have been involved in the review of over 100 applications for projects within the R2NC district and its predecessor, the RC overlay, which is sometimes still referred to. 20 or so of these projects have included demolition review. The property at 613 Chester Avenue is within the R2NC single-family residence neighborhood conservation district. The purpose of the R2NC district is to preserve patterns of design and development in residential neighborhoods characterized by a diversity of styles, and to ensure the preservation and diversity of land uses together with the protection of buildings, structures, or areas, the destruction or alteration of which would disrupt the existing scale and architectural character of the neighborhoods. The general purposes include protection of the architectural massing, composition, and styles, as well as neighborhood scale and character, compatibility of new construction and structural alterations with existing scale and character of surrounding properties, encouragement of existing types of land uses that reflect the mixture and diversity of uses that have historically existed in the community, and preservation of streetscapes. Within the R2NC district, new construction and structural alterations of existing structures, including demolitions, require site design plan review. The guidelines for evaluating site design plan review application in this district are laid out in the base district regulations for the R2NC district, the site design standards in section 21.22.080 and section 21.40.060 C2C, as well as the guidelines for relation of proposed structures to adjacent developments established in section 21.62.020B 1 through 13, and with the demolition standards in section 2114.040 and section 21.40060 C3B. These are the standards and review criteria by which we evaluated the application for 613 Chester Avenue, and based on our approval upon finding that the proposal complied with the city code. The appellants claim that the approval of additional height allowance is erroneous and is not supported by the facts. Section 21.50050, the bulk regulations for the R2NC district, at table note 9, provides for the Director of Planning and Zoning to allow a tolerance of no more than 10% of the maximum height upon finding that the tolerance is necessary to provide for adequate living space and compatible design, will not diminish an adequate supply of light and air to adjacent properties, and that the tolerance would not grant a height greater than the maximum height allowed in the underlying zone. The application for 613 Chester Avenue includes a request for an 18-inch tolerance to the 26-foot height limit, which is only 5.8%, which is less than the 10% tolerance allowed. We did find that the applicant's request meets the criteria for allowing the 18-inch tolerance, so it was granted. The appellant's claim regarding this point is not supported by the facts, and the decision of planning and zoning should be upheld. The appellant's claim that the calculation of the front yard setback is erroneous and not supported by the facts is not supported by the facts. Within the R2NC district, table note 6 of the bulk table provides the front setback requirements. The front setback shall be the lesser of the minimum specified in the bulk table or the established front yard pursuant to chapter 2138. If a structure is demolished for purpose of new construction, the new structure must maintain either the front yard of the previously demolished structure or the front yard as required by the established front yard. The established front yard in chapter 2138 is based on the average of structures on the block face. The subject block face only has one other house besides the subject property that fronts on Chester Avenue, so there can be no average setback. Even if there was an average, the overreaching principle in this district is that the front setback requirement is the lesser of, which in this case, the setback of the previously existing structure is the lesser of. The plans that were approved for the proposed replacement structure have the one-story front porch feature set at the same front setback as the entry porch feature of the previously existing house, and the main body of the proposed house is set further back at the setback of the main body of the previously existing house. This complies with the code requirements outlined in the bulk regulations table for the R2NC district. The appellant's claim regarding this point is not supported by the facts. The decision of planning and zoning should be upheld. The appellants claim that the front elevation is inconsistent with the scale and character of other houses in the immediate surrounding area is not supported by the facts. Planning and zoning did evaluate the proposed design using the review criteria that I previously mentioned. The design elements of the proposed house can be found throughout the immediate area of the neighborhood. The proposed house complies with all the setback requirements, height limit, and maximum allowable lot coverage. The front elevation was revised to push the main body of the house back from the face of the front porch. The roof system was simplified by eliminating some dormers in the front gable, and the window arrangement was changed to provide balance. Planning and zoning found that the proposed design that we approved is compatible with the distinguishing contributing characteristics of the majority of the surrounding properties. The appellant's claim regarding this point is not supported by the facts, and the decision of planning and zoning should be upheld. I didn't know we were going to get into the demolition, but the demolition review was not contested by these appellants during the application. They focused strictly on the design of the replacement structure. But during the review, we did send the application to the Chief of Historic Preservation for her input in the application for demolition, as far as the assessment of whether or not it was a contributing structure. And of course, her answer is in the record. Those comments were sent back to the applicant to respond to, along with requirements for structural analysis. And the applicant or the architect came back, who is in the record is a historic, what do you, Terry, a historic preservationist or whatever, historic architect. So, so Mr. Averill gave a detailed assessment of the application, or of the evolution of this house from the original circa 1932 structure that was a 2-bedroom structure that was then added onto with a small addition in the late 30s or 40s, and then another extensive addition in the 50s or 60s, and then other substantial alterations that happened in the 70s or 30s. So with that, we found it reasonable to determine that the structure had been altered to such a degree that its contributing features have been compromised to such a effect that it was no longer a contributing structure and couldn't be found to be a contributing structure. So that allowed us to grant the approval for the demolition, in which case we then focused on the design of the replacement structure. So the record supports the department's decision to approve this project, and as such, the decision of planning and zoning should be upheld. Thank you.
Thank you, Mr. Scott. All right, do my board members have any questions for Mr. Scott? Andrew, Rob? No?
No, I did have one question. With regard to the 10% on the height, how many other houses in that area are within the 10% but are over the height requirements?
None would be over the height requirement. So this tolerance for the 10%, we have granted that in every case that it's been requested. So the tolerance doesn't allow you to allow a height that exceeds the height limit. So the overall height limit in this district is 35 feet, which is pretty common throughout the city. So this district, it's the height limit is the greater of 26 feet or the average height on the block face. Again, there's no block face, so there's no average height, so you're stuck with 26 feet. Even if you have taller houses around you in the vicinity, they're not part of the average height. So this tolerance was put into the code to allow the department to use its discretion through the design review process to give more flexibility to allow for living space and compatible design. And that's what we did. So it was within the 10% that we're allowed to grant.
Okay, thanks.
More questions? All right, Kevin. So is it fair to say that that your office disagreed with the advice that you got from the historic preservation person regarding significance?
Well, when we initially received that, we obviously took it seriously. We forwarded it to the applicant to respond to it, to gather more information. It was only after receiving the additional information about the structure that we then disagreed at that point with, knowing the additional information about the structure.
I think Mr. Lomax raised an issue about the process for getting the engineer's opinion.
Okay, so this application came in back in February of 2020. We followed the code that was in effect at the time of the application. The ordinance that changed wasn't the code that was required. The part of the ordinance that requires the department to hire at the applicant's expense to hire a third-party structural engineer. That was not part of the process. So he's referring to code that wasn't in effect with this application.
Yeah, I'm sure he didn't know that.
But we did use the code criteria that was in effect at the time.
And the review by the Historic Preservation Division, was that required, or was that just something that you asked for?
It's not required. We use our staff. We have a lot of different talents throughout the department. We have some people that are very versed in like food service matters, some in critical areas, building code stuff, other design trees issues. Historic preservation is one of our talents that we have in our department. So we use the talent that we have, and we sought the advice of a staff member.
And do you know Mr. Wallace to be a qualified engineer, and you were satisfied with his opinion?
My understanding is he is a licensed engineer in the state of Maryland, which qualifies in this structural engineering.
Let me ask you about the height. So I read this note 9 little I-B. I guess I had the question. Does the 10% allowance, is it really available when you don't have an average? Just the language of that note raised that question for me. So I take it's been your position that the 10% is available whether or not there's an average.
Correct. We've always applied it as to the height limit. So whether it was the 26 feet or some height that was based on average higher, as long as the tolerance wouldn't then result in a height that exceeded the height limit in the underlying zone.
Okay. And how did you conclude that the increase was necessary for adequate living space when the foundation was being raised? I understand why you'd want to do that. It'd be a good thing to do. But we also have 9-foot ceilings on the first floor. So wouldn't they have adequate living space if they had 8-foot ceilings on the first floor?
I think adequacy is somewhat subjective, and it was our charge to make that decision. Everything's connected when you get into an overall design of the structure, to have a structure that the design is compatible. Everything is, everything comes together. So it certainly plays into the living space. So it certainly has to do with compatible design, which then in turn is connected to living space.
Okay, on the setback, the front setback, so you're telling us that the corner of the new porch closest to the street is no closer to the street than was the corner of the existing building.
The front, the leading edge of the existing building to the leading edge of the porch, the site plans show that.
Okay.
As you can see the existing footprint of I'm calling it the previously existing structure. It's obviously still there, but just as the language the code uses. Yeah. Yes, the existing house, the footprint is there, the proposed house is there, and you can see it doesn't.
And the new porch will be within that footprint.
The new porch doesn't sit right on the same footprint of the existing house.
It won't be any closer to the street.
Won't be any closer to the street. The new porch is oriented to the if you're facing from the street, off to the left side, whereas the current entry feature is kind of more centered in the house. So it'll be off to the left, and then the main body is pushed back. But you can also see from those site plans that the house is no wider than the existing house, and the front setback of the main body of the house is no closer than the main body of the existing house. And it's actually reduced the protrusion into the rear yard. So they're fitting it all within the parameters of the lot. And to the point of this, jumping ahead of you, but the compatibility and the size of the lot, I think it was referred to as a non-conforming lot, but the code allows that any lot of record is allowed to be developed with a single-family detached dwelling, regardless of the size of the lot, if it's a lot of record, as long as it can comply with all the zoning requirements. In this case, it does: setbacks, height, lot coverage. So it is a legal lot.
One last question. Mr. Lomax raises the question that's kind of based on 4 assumptions that I understand have some support in the record. The question is, so this proposal will now be the biggest house in that little group there. It'll be the tallest in that little group there. It'll be closest to the street of that little group, and it'll be just on the smallest lot. How can you have all those mosts and biggests and say it's compatible with the houses around it?
Well, I don't think all of those statements are correct.
Well, that's
it's probably not taller than all of the houses in the immediate vicinity there. It's not the smallest lot. I think one of the appellants may actually be on the smallest lot, come to think of it. And as far as the size of the house, it's like just over 2,100 square feet. I mean, initially it was a larger house, but during the review, we required them to push the main body of the house back, which they didn't just push the whole house back. They reduced the size of the house. So it's like 21 something hundred square feet of floor area of the house. It's 27.5 feet tall. It's not a McMansion by any means. So, and a lot of the appellants, I think the property owner is prepared to get into it, but they're living in houses that are a lot bigger than what this one is. So it's very in keeping. The style of it matches the styles that are found throughout the neighborhood. Nobody mentioned anything in the public comments about the particular design motif of like, oh no, you can't have that kind of stuff. They were fine with it. They objected to it's closest to the street is one of the things. And one of the things we had them do was push the mass of the house back by, the main body of the house has that 2-story element. It was pushed back, and that helped, we thought, minimize those concerns. Now, obviously we didn't make everybody happy, because even after they revised it, the commenters still provided negative feedback. Well, okay, we got to make a decision. We disagree with them.
Yep.
And we decided that it met the code requirements. I'm sure there's a million different ways someone can design a house, but we're reviewing what they proposed, and we found that what they proposed adequately met the code requirements.
Okay. All right. That answers my questions. Unless other members of the board now have questions, we'll move on to Mr. Lomax. Mr. Lomax, the floor is yours. You might be on mute. I can't hear you.
I apologize. I was on mute. Mr. Scott, I only have a couple of questions for you.
No, this isn't cross-examination. This is argument.
Well, then what I need is, if he is relying on a prior code requirement of the for the demolition, I just need to know what he's quoting, because I believe I know it, but I don't have it in front of me. If I could just get the language of the prior code upon which they relied, I can then address it. Position.
I'm sure they'll be happy to give you that information. Mr. Braithwaite or Mr. Scott, do you have it at your fingertips?
If you go on Municode, I'm sure you're familiar with our Municode site and how that works.
I am.
On the left-hand side, where the table of contents is, at the top, there's a version control. and you're probably looking at the current version, you can click the little down arrow and you can select any version you want back to 2012. So go back to,
I just went to
March, right?
that code, and I'm sorry, it is where?
Left side of the screen.
I see the left side of the screen.
You see version up there?
I see a little house. I see browse codes.
Would it be easier if I sent you the ordinance, Mr. Lomax?
Whatever way works. I'm on the Muni code. I just don't see the version. I see a version. All right. So if I click on the December 2020 version, I'll get an older version.
Well, the December 11th, 2020 is the current version of the code.
Right. And which
go back prior to 622, which I believe is when that ordinance that changed that went into effect. So go back.
That's what the note says at the bottom.
We got this application in February. So if you go back to the March 2020 or even the December 30th, 2019, that gets you into the code that was in effect at the time the application came in.
Okay. And then to get the one that was modified, I go down to, so Title 21 does not show anything as modified, frankly. So let me go to, what's that? It's 2140060.
That's the R2NC district.
And that's where the R2NC demolition is, correct?
That's correct.
Okay.
So if you're on that section, then you change the version, it'll update that.
2140 residential districts, 2140060 R2NC, and we go to demolitions, and the okay, we've got subparagraph 6 that says, in order to approve, the director may require a structural analysis of a structure or building by a registered structural engineer to determine if it is sound and not a threat to public health and safety before a demolition is authorized. Is that correct?
You're in.
I'm in F. I'm in C.
That's what I'm able to read in the code when I use the version, council.
Okay.
My version is the March 11, 2020 of 21.40.060. What version are you looking at?
I just happened to pull up the one, I think it was the March 20th, that seems to have the June code, and it talks about in subparagraph 3, Roman numeral 6, the director may require a structural analysis of a structure or building by a registered structural engineer to determine if it is sound and not a threat to public health and safety before a demolition is authorized. And I'm just looking to see if there's anything else that might be relevant, but everything else was addressed in terms of the loss of the structure, etc. So, Mr. Scott.
The procedures weren't in effect that are in the current code weren't in effect back then.
So, Mr. Scott, let me just then ask a follow-up question. In your June 10th.
So are we jumping into the cross-examination?
No, we're not having cross-examination.
No, I'm not trying to, I just want to make sure where that question about the code was asked.
Oral argument is not the place for legal research. So, Mr. Lomax, why don't you give us your argument?
All right. So let's start back with the initial application. It did not ask for demolition. In fact, the applicant's engineer specifically found that with a strengthened foundation The structure would support the proposed second floor and provided detailed drawings, and that's Exhibit C4 in the record. 3 months later, they proposed demolition, and that's Exhibit C5. The city obviously asked HPD division, not commission, HP division, and the division made detailed findings, which the city chose to take the rebuttal from the applicant. But those detailed findings were at Exhibit C2. The city then asked the applicant to provide a structural analysis that indicates that the existing structure is unsound and a threat to public health and safety. That was on June 10th. It's Exhibit C3. And that would then appear to comply with the requirements of the code then in effect that we just read. But what answer did it get? What it got was the applicant's architect saying, well, first of all, it got a response from the architect's engineer, which is C15, and this is what he said. The applicant was wishing to demolish the building in order to build a more aesthetically pleasing residence. That structural engineer did not use the word unsound, did not use the word public health and safety, did not address soundness, did not address health and safety. When none whatsoever. And the city didn't follow up and do anything with respect to ascertaining the structural integrity of the building or the structural ability. Instead, it simply relied on the architect to come back and say, oh, the loss of the structure would not be detrimental to the area, and that it was necessary, basically necessary to achieve a new structure. The architect, even though he has submitted that he is a Master of Arts in history, etc., did a good job at analyzing the history of the building, but did not at all address the unsound and unsafe request that Kevin Scott posed to him. That issue is totally ignored, and that's a fatal flaw. They were asked about it. That's what the code says they can ask, and they never got a response. Now, if they want to go back and get a structural engineer, that would be fine. But they did not do it. They did not follow the code, and that is an error as a matter of law by not following the code. When they asked that question and not getting a response, it was error to go ahead and permit the demolition without that having been resolved. With respect to the height, we submit again, it's just a simple issue of not following the code. As the chair pointed out, 2150-050 controls, and that requires a 26-foot height, except that the director may allow a tolerance of no more than 10%. And this is critical to provide for adequate living space. That's not an either or. That is a provide for adequate living space and also meet some other requirements. We're not taking issue with the other requirements, but there was no finding of inadequate living space or a need for adequate living space. And the application itself omits any discussion about what is needed for adequate living. And the chair, you were correct in pointing out that what's the missing link is after you put 20 inches raise the building 20 inches off the ground, put a 9-foot ceiling on the first floor and have no dimensions whatsoever and no explanation whatsoever of what's going on in the second floor, or what is needed on the second floor, you have not met the burden of establishing a need for adequate living space. And that is a hard and fast requirement of 2150-050 table note 9, I believe it is. And it was simply not done. And in fact, as you pointed out, the 9-foot ceiling with a 20-inch, you can lower that house. It may take a little tweaking in the design, but you can lower that house. And Mr. Latazori's house, the only other house on that block, is 26 feet. It does not have a 27.5 foot or anything above the 26 feet. The houses of the other appellants that Mr. Scott alluded to, and that the applicant took issue with, and that they got a bigger house, why can't I have mine? Those houses are on a different block face. They're on a full block face. They have a height calculation based on that block face, and they have what their block face allows. But we're talking about the block face on Chester Avenue. Chester Avenue has one house, 26 feet. And it's on a larger lot than this adjoining lot. We're not talking about round the corner, but we are talking about Chester Avenue, and we submit that the code required that a showing of adequate living space be made. No mention was made of adequate living space other than to say, oh, it has adequate living space. But the real issue was that it was going to be, it was only granted for aesthetic reasons and to accommodate 9-foot ceilings on the first floor. If you drop the ceilings to 8 feet, you have no problem. You can pull that house down by 12 inches. And if you drop make it a 1 step up, instead of 2 steps up, you drop it another 7 inches, and you've got your 18 inches taken out right away. And you haven't done anything with the rest of the house, basically. So we submit that the height calculation was simply an error as a matter of law. They did not apply the law correctly and get the information necessary for adequate living space. Now, on the setback, I heard what Mr. Scott described, but it flies in the face of what their drawings show. So we agree that 2138-030 F3 is the proper one to code revision to apply, where you only have one other house on the block. And that provision, and there's a little illustration that I actually cut and pasted into my memorandum that says connect the nearest front corners of the existing buildings, and then use the midpoint of that line. If you go to the approved drawing, it's the sheet G1 and C11, you'll see the dotted line from the corner of the building on the right, Mr. Bernard's house. Dotted line connects to the porch, the front corner of the porch of Mr. Latazori's house. It does not connect to the front corner of his building. And on my exhibit A, or was it A? In my attachment to my memorandum, I believe it was A, I provided right on top of that approved drawing the actual line in red that is the true setback line according to 2138-030. And that house, as currently approved and cited, sits too far forward to the street. The face of the house needs to move back. And if they want to extend the porch in some fashion, they can submit a new drawing to extend the porch back out to its original location. But the face of that house has to abide by 2138-030 F3, and it does not. And that's a code requirement. They can't take apples and oranges. And if you look at exhibit B to my memorandum, you'll see the Latazori house and the current residence at 613 Chester, and you'll see the significance of the fact that the line was drawn to the porch and not to this building as the code requires. The code does not say draw it to the porch or mix and match, draw it from one building corner to another porch corner. Building to building, apples to apples. Do that and you have the correct computation under the code as to what the setback should be. To the third point on the compatibility, or the fourth point actually on compatibility, the chair also made the point that in part I was would make, and that is when you take the 3,500 square foot lot and you put the 27.5 foot with the height allowance on that lot and you set it up at the street, it changes the street, the block face. It changes the character of the street, the face. And again, if you look at exhibit C, B and C to the memorandum, there is a rendering of where the house as approved will sit in relation to that street face. And in part because of this large 2-story front-facing gable, which is right up front, that house is way over bulk mass scale sitting where it is situated. If it was on a bigger lot, if it was 15 feet off the street, if it had a full porch across the front or some other features that made it, that tempered the size of the house, we would not be having this issue with compatibility. But it's the combination of 2 errors of law, height and setback, combined with the design with this front gable that makes it incompatible with that street face. And that's the street face that we have to deal with. We're not dealing with Burnside. We're not dealing with 6th Street. We're not dealing with other streets. We're dealing with the low scale, small scale, 26 foot high house of Mr. Ladasori on that street face. And that's the problem we have with the compatibility. They all run part and parcel together. The demolition should not have been done without confirming that it was unsound and unsafe, or unsound and a threat to public safety, if that's the version of the code that wants to be relied upon. They have miscalculated, they've misapplied, or not done adequate, not determined why the second story is the floor to ceiling height is inadequate on the second floor. And they have miscalculated the setback, and the combination of all of that is to shoehorn this big structure, and I say big because it's big relative to the lot, and it's actually big relative to the house next door, onto this lot. And that's why we think there's error, both as a matter of law, and the overall granting for compatibility was arbitrary and capricious, and it has to be sent back for further review. There's no doubt in my mind they can come up with a more modest proposal for that house on that lot that is compatible with the street face, that is compatible with the code, but it just was not done in this case.
All right, questions from the board for Mr. Lomax?
No.
No, okay. No is always a fine answer. So let's hear then from Mr. Avril or Ms. Adams-Krieger, whoever would like to speak for the applicants.
Thank you, Mr. Chair. We followed the building code and the zoning code as best we knew how and went through the process as need be. I think Mr. Lomax's contention with regard to a line that I drew was a reference line. And I think Mr. Scott could verify that the corner of a building is the corner of the building, and it's based on columns. And in this case, I think it is Mr. Ladasori's house has a corner. I drew a line between that corner and the corner of, I think it is Mr. Bernard's house on the corner. That is a reference line only. It is not, has nothing to do with any means of measuring anything other than to say that the mass of the newest design sits behind that line. That's all that was. There is no measurement on that particular street because there's no average front setback because there's only one house. So in this circumstance, the house that was demolished had a face. That face has now been mimicked with a porch, which is of course more open than what I call the nose of the old house. And then the mass of the house, through a redesign 2 months after the initial submittal, was pushed back, and the overall square footage was reduced to 2,100 square foot, which by any stretch of the imagination is relatively small for that area. In fact, it's probably the smallest house I've designed in that area or in Eastport in I can't remember how long. It is a small-ish lot, but there's no determination that because a lot is 3,500 square feet, as long as you meet the setback, and Mr. Scott did mention this, if it meets the setbacks, it meets the setbacks. If it meets the height, it meets the height. So we're not asking for anything other than the one thing that this department can request or authorize, 18 inches to the height of the building. That was done for an aesthetic purpose, is the primary reason, to make it a steeper pitch roof so it would look more like houses in the neighborhood. So It is not a big house. It is a relatively small lot. The area it takes up on the lot is actually slightly smaller than next door, which is Mr. Latazori's lot, which is the smallest lot around. As far as aesthetics, that can be argued all day long about whether something is compatible, it is not compatible. It's a very subjective notion. If I hadn't done so many in the area, it might be problematic, but the fact is I've done at least 5 all within that area, and none of them have gone through this kind of rigmarole over a design. What was the other contention? We got height, we got compatibility, and we got setback. As far as the demolition, the house is not contributing. It is in fact a dilapidated conglomeration of pieces of material. It is standing up. It is not going to fall down. If that was the intention of that structural writing, that is beyond my understanding of it. If a house isn't going to fall down, therefore you can't demolish it because it has no historic character, that's an interesting interpretation, but that's apparently what Mr. Lomax is saying. You can't tear down a ranch if it's going to stand up. Okay, well, interesting. I think Mr. Scott could kind of and give us more information about other demolitions that have occurred in this vicinity, because there have been a lot, some of which I've been kind of aghast at because there have been historic things that have been recently taken down in Eastport. But be that as it may, this was not historic. And you might ask Mr. Bernard, and since he is here, about the house that he had demolished in order to build his own house. And it was in much better condition than the one that we're talking about now. Now, I wasn't around, nor did I comment on it at the time. And this was all during the same period we're talking about.
Well, we won't need to do that. We're not hearing any new evidence on whether the Planning and Zoning Department got it right in another case. Doesn't matter.
Right. So I guess can I ask why are we, and I do have to wonder why we're talking about the demolition in the first place. I don't know whether Mr. Braithwaite whether it is considered that was not what the original appeal was about. And that's been the primary thing we've been talking about. And it is kind of odd that we're talking about it because it wasn't one of the 3 points of the appeal. But be that as it may, that's what's been discussed.
All right. Anything else you need to tell us?
No, I did in a letter I submitted a few days ago, and you all might refer to that site plan so that you have a better understanding about the neighborhood scale of buildings around. And I drew that so that everybody understands that this is not a big house. There's no question that it's relatively modest. So this idea that somehow it's big, tall, and overwhelming on the street is just not accurate.
Yeah, okay. Do any of our representatives of the parties here feel like they need rebuttal? Or first of all, are there any questions for Mr. Averill from the board members?
Actually, I would like to add something to what Mr. Averill has just stated. This is Michael Adams,
Yep. Okay.
and Mr. Averill is my architect. I find it a little unsettling in that we're, first of all, having a discussion about the demolition of the site. And I think that the discussion plays into Mr. Lomax's strategy in that it was not even a consideration when the appeal was filed, because there were 3 matters for discussion, and it's not for me to decide how the board conducts its business. But in order to move forward with those 3, it would mean that we would have to have accepted that the demolition is already concluded, or the decision to demolish the site has already been accepted. Now, the whole conversation about this at this point, demolition at this point, is exactly what has been going on for months on end, which is consistently introducing ideas that would defer and delay the process of demolishing the home and erecting a different structure on the site. Now, I find this to be quite unnerving. I submitted actually a letter to the board, which outlines in graphic detail how I feel about the process that we're engaging in. And I think that it's appalling that we're at this stage that Mr. Lomax and the clients are still shamelessly engaging in the same delay tactic, which hopefully I am thinking might defer my objective of raising the building and erecting a new home there. I genuinely ask that the board comes to a conclusion on the merit of what is actually happening and the subtlety of what the appellants under the guise of Mr. Lomax is engaging in, which is a continued effort to try and drag this process on to make it as unbearable as is possible for me.
Thank you, Ms. Adams-Krieger. We're going to decide this on February 5th.
Thank you.
I would like a very brief rebuttal to both of those comments.
All right, let's give Mr. Braithwaite his chance first.
First, we would say that, as discussed by Mr. Scott, they talked about the pattern and practice at the City of Annapolis of never denying a request for additional height. And so I don't believe that additional height should be a reason that this board vote to overturn the city's decision. You have heard and that the record that was developed to support to understand the contention that this house was somehow historic and contributing. You have heard that there was a response in the record that discusses that the house, if the core was in fact made it at a historic time, the changes to the house and the renovations over time diminished the historic nature of the house. And now the house is just a conglomeration of many different renovations without a particular historic contributing factor. You have heard from Mr. Scott that the front setback, the applicant is entitled to the front setback of the prior property, despite the fact that they have shifted the first place that the property meets the setback line to the right or to the left of the house. As you look at the house, it doesn't change the fact that that's in line with where the nose was previously. And I would just rest with, this is a process to allow the applicant to get to the highest and best use of a property. Every property owner is entitled to develop their property within the bounds of the law. Nothing in the design, it's not a clear plastic or a glass house or a container home or any of these things. It's a very aesthetically pleasing design that's consistent with and compatible with the design of other houses in the neighborhood. So with that, we would ask that the board uphold our decision. Thank you.
All right, Mr. Lomax.
Thank you. I want to address first the applicant's comments, and I'm not going to address the pejorative insinuations, frankly, but I am going to say it is absolutely incorrect that the purpose of this is to delay. My clients are not trying to block any reasonable, realistic, code compliant project. But what my clients want is that the city follow and not make errors in law in making that determination. Follow the demolition code, follow the height code, follow the setback code, so that this structure is not stuck out on the street and not compatible with the block face. At one point, frankly, now that she's raised the issue about motives here, the applicant actually offered to move the house back an additional 4 or 5 feet.
You don't need, that's evidence we don't need to hear.
All right.
We gave her a little slack because she's not a lawyer. You know better.
Well, she opened that door, but let's go to going to the demolition. The structural engineer on 2 occasions had an opportunity to make a determination that it was unsound and unsafe to the public health. He did not make that determination. What he determined is, and he provided plans that the original design was perfectly able to be done encompassing the existing house. It didn't have to, it modified the existing house, modified the foundation, and put in a perfectly acceptable house. The applicant only later said, you know what, I think I just want to demolish it. And when that happened, then the city needs to follow its code. And they asked for a structural report. They did not get a structural report, and that is fatal as a matter of law. The third point that I want to make is that Mr. Averill pointed out that argues that this line that he drew was an example line or something. If the board needs to look at Exhibit G1 in C11, that line is exactly where the front face, the line connects Mr. Bernard's corner of Mr. Bernard's building and the corner of the porch on Mr. Lattisore's house. And Mr. Averill argues that because there is a column on that porch, that is the proper connection. I could concede that if in fact the porch on which of the proposed house, which also had columns, if those columns were pushed back to the midpoint of the same line, that would be apples to apples. And I said that in my memorandum. If you're going to go to the corner of the column on the porch, then you have to use the column on the porch on the proposed house. If you want to go to the corner of the main building, which I suggest the code says, then you've got to put the face of the proposed building at the midpoint of that line. You can't have it go both ways. You can't have the drawing go from building to porch and then decide that you're going to not set the porch back on that line. And that's the error. If that's going to be the position that the porch comes into play as the building, then you have to use apples to apples. And
is it possible that I respond to that particular comment?
No.
Okay.
And I just want to thank the board for its patience. And I also thank the board for the opportunity to take a little bit extra time so we could put this together from January. I know that was over objection, and I appreciate the indulgence on that. And hopefully we won't miss much of Bruce Springsteen.
All right, Mr. Averill, now you may.
Mr. Lomax was saying that he wanted to make sure that we go by the law, and the law says we have to retain the front of the building where the front of the building was. And the front of the building, based on his measurements, is a porch, and that porch is where I've drawn the porch. And since that is the setback, that's the setback. In order to push the building back further, I would have had to go through an administrative adjustment or some type of variance, which I would have had to in some way word a hardship. And in that case, the hardship would have been, the only thing I could come up with was neighbors didn't like it the way that the law was written. So we had to go against that law and push the building back. So I think Mr. Scott can help with that argument. We set the porch where the porch needed to be. I drew a line from a porch to a building just to indicate that really the mass of the building is behind that line, so it should be adequate. That was a reference line. It had nothing to do with measuring anything. It just made it seem that the mass of the building is pushed a little further back. And that was a change that we did in the design based on community comments. So the porch is where it is because we have to maintain that. The mass of the building went back, which is more or less in line with the mass of the building that was there before. And that was just all to address the actual requirements within the law. And that is what Mr. Lomax is asking for.
Okay.
Can I make a comment about the established front yard and how Mr. Lomax was interpreting that code section at 2138.030? So first of all, porches are subject to setbacks. So you would measure to the porch. Covered porch has to meet the setbacks. So the established front yard, it says that you compute the front yard and the established front yards of the buildings on the block. It repeats the term front yard. So it's always talking about the front yard setback and the front yard of the other structures on the block face. The graphics show houses with front yards. It doesn't have any illustration that would indicate that you would measure a building that is a corner side yard to a block face. So to this notion that you have to use the house that faces the side street is not part of an established front yard. So there is no established front yard. The standards in the R2NC talk about observing the historic front setbacks and building heights pursuant to 2150.050, which is the bulk table, if any. So it implies right in the design review standards that there's a possibility that you may not have an established front setback or average heights for the block face, because it says if any. So I maintain there's no established front yard. So we go with the setback of the, in this case will be the previously existing structure. Once it's demolished, would be the setback for the replacement structure. So
that's very helpful.
The other comment that was talked about was with, I guess, adequate living space. I mean, it's not a defined term. Okay, what is adequate? I mean, a 9-foot ceiling to someone might be just what they need. Someone else might be able to get by with 7 foot 10 inches. I mean, what is adequate? We reviewed what was applied for and determined that they met the criteria to determine that it was adequate. We didn't review all of the appellant's various versions that, well, what if you did this? What if you did that? We're not reviewing all of the ifs and buts and what ifs. We're reviewing what was asked for by the applicant and find that it's compatible. But as far as the photoshopped illustration in his memorandum, I have no idea what the accuracy of that drawing is. It's not something that even has a label on it of who drew it or what their credentials were to draw that. So I don't know how that weighs in this.
Okay. All right. And one more chance for questions from the board? Mr. Dews, Mr. Burnett, anything?
Nothing for me.
Nothing for me either.
All right, thanks. Let me just make one response to the applicant, Ms. Adams Krieger. The members of the board are not city employees. We're volunteers sitting on a board established by the city council for the purpose, the way I think of it, with no offense intended to our friends at Planning and Zoning, as a check by citizens on the tyranny of the bureaucracy. But our tools in discharging that job are also created by the city council. And in doing so, the city council has tried to balance the need for reasonable procedures and expedition for people who want to improve their properties to get through a complicated process, much of which is dictated by the state. And balancing, on the other hand, the rights of citizens who have views on that as it may impact them and their life in the neighborhood to be heard. And so those are the tools the board has. We don't have any control over a case until it gets to the board. And when it gets to the board, we try to get it processed as quickly as we can within our ability to hold hearings and have, the parties available for the hearings. We are aware that some parties in some cases may try to take advantage of those procedures for delay purposes, but it's very hard to challenge someone's intentions. We don't know what other people's intentions are, and I try not to judge those, and I think it's better if the parties don't either. It just makes for a hearing that will go more smoothly. So I think we've heard everything we need to hear in this case. We'll meet again on February 5th. I apologize for raising my voice earlier, but I was just trying to keep this thing on track. And we'll have a decision for you on February 5th. Thank you all for your cooperation. And the Springsteen fans can still get to listen.
And I
think that's February 2nd.
February 2nd, sorry. Beg your pardon. Yeah.
And I would just like to congratulate Mr. Brathwaite and Ms. Wood on their association with Howard University. It's a monumental day today for Howard.
Yes, it is. It's a monumental day today for everyone, in my opinion. All right.
Thank you, Mr. Chair, for taking the time to explain that. I appreciate your time and I appreciate your consideration and generosity.
Yeah. All right. Thank you all. Be safe and Good night.
Good
Night.
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 Good night, everyone.
Good night.
Night.
Aye, aye, aye. All right, drinks.
I do have-
Aye, aye.